This is Lecture 6, the Novelty Requirement 2. The agenda for this lecture is to go through first the first to invent system that was the system in the United States until the end of March 2013. And then to talk about the first to file system, which replaced the first to invent novelty system as of March 2013. And then talk about some details of the novelty requirement under the new law, exceptions and exclusions, and so forth. First of all, let's talk about the first to invent. That's the current regime, right? So here's our current 35 U.S.C. 102 subsection G, which is in effect until March 16, 2013. A person shall be entitled to a patent unless, during the course of an interference, another inventor involved therein establishes that before such person's invention thereof, the invention was made by such other inventor and not abandoned, suppressed, or concealed. And G2 says before such person's invention thereof, the invention was made in this country by another inventor who had not abandoned, suppressed, or concealed it. Right? So subsections 1 and 2 are the same, except that subsection 1 deals with a different kind of procedure, which is called an interference proceeding. An interference proceeding occurs inside the patent office when the patent office discovers that two potential patentees are claiming or attempting to claim the same invention. They will declare what's called an interference, and at that point there'll be essentially a proceeding inside the patent office to determine priority of invention. Subsection 2 deals with the general case of litigation after a patent has been granted, then allows the fact that somebody else earlier invented that same invention to be essentially a defense, a reason that the patent at issue is invalid. But other than that, they offer the same basic idea. And the idea here is what a 102G sets up is a question of first inventorship, and it awards a patent to the first inventor, right? And so you can tell that before the person's invention thereof, the invention was made by another and not abandoned, suppressed, or concealed. Before the person's invention, right? So the key date again here, as we talked about in the last class, is the invention date. Right, and so one question is why the abandoned, suppression, or concealment? Right, so the reason for this, I think, is very similar to what we saw in the Gaylor versus Wilder safe case, where the idea here is that somebody, even though somebody may invent a new invention, if that person abandons it, suppresses it, conceals it, or otherwise deprives the public of the benefit, then they in fact haven't done what we would call invention in the patent system, right? Although as a technical matter they may have invented something, if it hasn't actually inured to the public's benefit, then it doesn't count to some degree. So that's why the abandoned, suppression, and concealment. Now 102G goes on to describe the following. In determine priority of invention, there shall be considered not only the respective dates of conception and reduction to practice, but also the reasonable diligence of one who is first to conceive and last to reduce to practice from a time prior to conception by the other. Right? So this is 102G not only tells us it's first to invent, but also has this paragraph describing how we're supposed to evaluate first to invent. Right? And words like conception, reduction to practice, reasonable diligence are all going to come into play, and let's go through how that works. All right, so first to invent, right? So 102G, as I noted before, established in the United States as a first to invent system in virtually the entire rest of the world. In fact, that as of 1998, I believe, the entire rest of the world has some version of what we would call a first to file system. A first to file system, briefly, is different in the sense that the first person to file a patent application for a particular invention is the person who gets the patent. Our system is different, right? It's not first to file. Our system is the first person to invent, right? This is open to debate about what's the right approach, and it's been hotly debated in the United States. Obviously, we were an outlier for a long time. Some things to consider, which is better at determining the real inventor and being most fair to somebody who has truly invented something new. Many people argue that the first to invent system better allocates the patent right to the true inventor, right? The argument for first to file is that it's simpler, right? It's a lot cheaper, a lot easier. You don't need to try and prove inventorship, which, as we'll find out, can often be somewhat difficult. And so it's not. It is administratively easier to set up and maintain a first to file system. Incentives are pretty different, right? So first to invent, you obviously want to be the first person to invent, but you might have less incentive or somewhat less incentive to disclose your invention or to file for your patent application until you're ready to file for your patent application. Whereas in a first to file system, obviously you're going to have very strong incentives to file your application early because it's going to be critically important to get that application in early. Now, that is not to say that there aren't a lot of aspects of the U.S. patent law as it currently stands that encourage people to file early. We're going to see a bunch of those throughout this course. But just noting that as between the two, certainly first to file would send people more quickly to the patent office. Now, that has a number of implications as well, right? Does that change the way that people do innovation, right? Are people going to go for smaller inventions that don't take as long a sort of research and development process instead of going for the big home runs? It might take a lot longer, where you might lose the race to the patent office. Is it going to change? Is it going to have distributional consequences, right? The people who have a full staff of patent attorneys who can rush to the patent office right upon an invention may have an advantage in a first to file system as opposed to first to invent, where you can essentially take your time and as long as you can prove your earlier date of invention, you're going to be okay. Right? But in any event, that debate was resolved in Congress as of last fall, and as of this March, we'll be moving to a modified version of the first to file system. We'll talk about what that means. All right. But let's talk about the rules of priority now. I think it's important that you understand that these rules are going to be with us for 20 more years, right? Because patents terms begin with their filing date and last for 20 years. So, for much of your careers as patent attorneys, you're going to see the patents that were filed and used under the old regime. So it's important to know these rules as well as the new rules. So the basic rule of priority is that the first person to reduce to practice is the one who gets priority, right? That's the simple rule. Just remember that. There you go. Now, there are two exceptions, right? Exception A is that if somebody conceived prior to your reduction to practice and was diligent, then they can win, right? So a prior conception with reasonable diligence until they reduce to practice can defeat somebody who reduced to practice before. And the other exception is that if you were even if you were the first to reduce to practice, if you abandoned, suppressed, or concealed your invention, then you do not get priority. Right? So I think one of the easier ways to work through this is just to get through a few examples. Right? So we have two inventors here, inventor A and inventor B. They have a date of conception, a date of reduction to practice, and a filing date for each one. Right? All right, so scenario one. Inventor A conceives on January 1, inventor reduces it to practice January 2, and files on January 3rd. Inventor B conceives on January 4th, reduces to practice January 5th, and files on January 6th. Right? So this is the easiest case, of course, because you look at the reduction to practice dates, right? January 2 versus January 5th, and inventor A wins, right? Again, you could then say, do any of the exceptions apply? Did inventor B conceive first? No, inventor B conceived later. So inventor B doesn't have an opportunity, and there's no evidence here that there was abandonment, suppression, or concealment in any way, especially since there was a filing the day after reduction to practice. Right? So A clearly wins the priority here. All right, let's change the dates a little bit. Right? So inventor A now reduces to practice on the 3rd, but inventor B reduces to practice on the 4th, but inventor B beats them to the patent office. Okay, so inventor B files on the 4th, which is before inventor A does. Okay, now how do we resolve this? Well, again, we end with the basic question, right? Who reduced to practice first? Inventor A reduced to practice first, so inventor A has priority. Did inventor B conceive first? No, inventor B conceived after inventor A. So that's the rule. Now note that because inventor B filed here earlier, right, inventor B will have some advantages in an interference proceeding in that inventor A will have to prove that that their filing date, that they have a reduction to practice date prior to their filing date. Right? The way the Patent Office deals with priority is they assume that your date of filing is your date of reduction to practice. Right? And then they go from there. You can prove an earlier date of reduction to practice and indeed an earlier date of conception if you have to, but the PTO will, without further information from you, assume that when you file is your date of reduction to practice. Right? So that means inventor B will be what's called in an interference proceeding the senior party and have some procedural advantages, although ultimately if inventor A can prove up these dates, they should win priority. All right, so let's look at another scenario, right? All right, inventor A conceives first, but reduces to practice second, right? So inventor B both reduces to practice first and files first, right? So the answer to this one, right, is that inventor A can win as long as inventor A can show the earlier conception date and the reasonable diligence that they worked to the reduction to practice. Okay, so that is one of the important exceptions, right? And this will play a part in some cases. All right, so the case I had you do for this was the Markahar case versus CR Bard. Bard's about double lumen catheters, extremely important inventions in the medical field for double lumen catheters. The idea being that you could have a single needle, a single catheter that could both introduce fluids and remove fluids at the same time, allows all sorts of new sort of medical techniques and so forth. So this is about that's the technology involved here, right? So the timeline and what Markahar goes through is how to figure out whether somebody has priority or not. But let's talk about how this works, right? So B files first in this scenario, A files later. Right? Who wins? Well, B wins for the reasons, assuming we know more information than this, B is going to win because we assume that your filing date is your reduction to practice date. Right? And indeed, filing dates are called constructive reduction to practice dates. Right? So the PTO will, again, without further information, just decide that your filing date is your reduction to practice date. Right? All right, but let's say that A comes along and says, no, I should get priority because I can backdate my priority to my reduction to practice, and they can prove that date, right? So they should be able to win unless B can now come along and prove an even earlier reduction to practice date. Again, first date of reduction to practice wins, okay? All right, let's look at another stage here, all right? So at this stage, who's going to win? Well, B is the first to reduce to practice, but A is the first to conceive, right? So now A should be able to win, according to the statute, as long as A had what the statute describes as reasonable diligence. Now, what does that mean? What does it mean to be reasonably diligent? And when do you have to do it? The question here is when the reasonable diligence period is required. And here's the way that this works, right? So A is required in order to win this priority contest to show that A was reasonably diligent from a time just prior to B's conception until A reduces to practice. Okay, so you might be a little bit puzzled. Why don't we require A to be reasonably diligent through the entire time period from when they conceived till they reduced to practice? Why say that when they have to be diligent is really only that time period from just before B's conception until A's reduction to practice, right? And the idea here is that we don't care that much from society's perspective if A sort of doesn't work very hard, as long as they're the first one to pick it up again and start working, right? And because in some sense society hasn't lost anything out by giving A priority there, because A was still the first person to invent and was working on it at least just prior to B's conception. So as long as A can show that they were reasonably diligent from a period just before B's conception and all the way through a reduction to practice, then they should be able to win, A should be able to win this priority contest because of the earlier conception, a diligent reduction to practice from a time just prior to B's conception. Right? So what is reasonable diligence? Well, the case law is mixed on reasonable diligence. It varies by circumstance. There's a variety of cases that say things like, waiting for a grad student is not reasonable diligence. Losing funding is not necessarily reasonable diligence. On the other hand, you don't have to be working on it 24 hours a day, 7 days a week, right? The key word here is reasonable. You have to clearly be working on it, clearly moving the project forward in some way. You can't be taking a hiatus from working on the project and still call it reasonable diligence, right? All right, so Marquardt also deals with the issue of a corroboration requirement, right? And this is important to understand, which is any time that you are testifying or offering evidence with respect to dates of conception, of reduction to practice, things like that, you can't just have testimonial evidence that will be accepted. There has to be a corroboration of everything, right? Whether it's third-party corroboration or, most importantly, some sort of contemporaneous documentation, lab notebooks, photos, record keeping, publication, something to corroborate the testimony of the dates. This is critically important because otherwise you could imagine the evidentiary problems of trying to figure out whether somebody's telling the truth about when they conceived of an invention is really important. Or it could be really difficult. So the corroboration requirement forces patentees, challengers to patentees to corroborate all of their dates of invention, conception, reduction to practice with some sort of documentation, right? So this then creates a pretty strong incentive when you're working in the research context to make sure that you're keeping good records. Right, I mean, this becomes pretty important. Good records are important, especially records associated with dates and times and what exactly the stage of development of the project was at any particular point in time. Okay, so that's the basic priority system that we have today. And again, you'll do fine if you remember. First to reduce to practice is the priority winner, subject to a couple of exceptions, abandonment, suppression, concealment. But the more important and interesting one is a prior conception. All right, so let's look at first to file. All right, so again, first to file comes into play this March, and this is all about effective filing date. You'll recall this from the last class. effective filing date is the key, which means really there's no more 102G rules of priority. Right? There really isn't such a concept as a rule of priority. It's a pretty easy rule of priority. It's the first one with an effective filing date. Remember, effective filing dates don't necessarily mean the actual date you filed, right? Because you might be able to take advantage of an earlier filed application, either in the US or abroad, that would get you an earlier effective filing date than the actual filing date you have. But in any event, it's all about the filing date now, right? And so this is it, right? I mean, it used to be that there was a fairly complicated system. You can remember this timeline that in the last section of this lecture we filled out. Here, that's it. B's going to win, right? Now, there are some exceptions, and this is where it gets slightly tricky to understand our first-to-file system, right? Okay. So here's some exceptions, right? So disclosures made 1 year or less before the effective filing date of the claimed invention shall not be prior art if the disclosure was made by the inventor or joint inventor or by another who obtained the subject matter disclosed directly or indirectly, or B, the subject matter disclosed had before such disclosure been publicly disclosed by the inventor or a joint inventor or another who obtained the subject matter disclosed directly or indirectly from the inventor or a joint inventor, right? So that means, right, there's a form of a grace period for the inventor, right? Right? So as long as a disclosure is 1 year or less before the effective filing date, right? And it fits into either one of these categories, A and B, right? A is disclosures by the inventor or derived from the inventor, or B, disclosures by others if the inventor or somebody who derived from the inventor published first. Okay? So it gives a form of grace period for the inventor, which means you can go ahead and publish. You don't have to immediately file your patent application. You have to do so within 1 year. And not only do you not have to, not only can you publish early, but there's a pretty strong encouragement here to publish early, right? And we'll talk a little bit more about that in a moment. Right. So another set of exceptions, right, is disclosures appearing in applications and patents. Right. A disclosure shall not be prior art if the subject matter disclosed was obtained directly or indirectly from the inventor. The subject matter disclosed had before such subject matter is effectively filed under A2 been publicly disclosed by the inventor or another, or the subject matter disclosed in the claimed invention not later than if were owned by the same person, right? So basically three things here. There's an exception for derivation, right, which is a similar exception as to the one we saw before, where if the first publication was the inventor or somebody who derived from the inventor, then it will cancel that out. And if the subject matter disclosed and the claimed invention were owned by the same people, so a common ownership exception, even if the inventors are slightly different, right? So this is a derivation defense, right? Number A is a derivation defense, means that you can cancel out prior art that appears in applications or patents by saying it was derived from your invention. And it's similar to the earlier exception here. B, we talked about already. Prior disclosure by the inventor is also an exception. And then the common ownership exception. Right? So one of the interesting things about our new section 102 is that it does away with this concept of interferences. We will no longer have interferences in into the new regime, but it replaces it with a derivation proceeding, right? And it effectively gives a civil action, a civil remedy against a patentee who derived her invention from you. So you can actually sue somebody who gets a patent if you can prove, and you can win, and it's not clear exactly what you would win, but you would potentially get the patent and maybe even damages, not clear. You can it offers a civil action against a patentee who derived the invention, and it offers a proceeding at the PTO, which ultimately is intended to make sure that inventorship is proper. So in a sense, this looks a little like an interference practice, right? Where there's a contest over who actually is the true inventor, but it's not about the date of inventorship. Instead, it's about derivation. It's about did they, meaning the competing patentee, somehow get the information about the invention from you as opposed to doing it or making it themselves, right? So the old 102F made derived inventions unpatentable, right? So it's similar to that. So this is not an entirely new concept to the patent law, but it is something that does away with interferences, institutes this new proceeding that we call derivation, and it'll be interesting to see how this all plays out. And one of the interesting things that I want you to think about as you're going through the readings here is what are the incentives under the new first-to-file regime, right? So first, as we talked about a few minutes ago, there's a very strong incentive to publish your invention early, right? Two reasons. One, your disclosure can cancel out somebody else's disclosure as long as you're the first person to disclose, right? So if you disclose and then within a year you follow it up with a patent application, you don't have to worry about anyone filing a patent application or disclosing before you because you have essentially pre-disclosed the invention. So it gives us pretty strong incentive to get out there and publish, right? And second, your disclosure can block somebody else's patent, right? It can essentially prevent somebody else from getting a patent, irrespective of if you're the first to disclose, irrespective of whether you follow up with your own patent. You can certainly block somebody else from getting a patent. I mean, imagine the scenario where you published a paper, but you didn't file your patent application until 13 months later. Well, that disclosure then that you made is not protected under the grace period, so it's prior art, and if it covers your claims, then you will not get a patent. Right? So it's good prior art. On the other hand, no one else will either, right? Because it's good prior art against not only you, but everybody else. So although we talk about our system as a first-to-file system, in reality, in operation, it works a lot more like a first-to-disclose system. Because although you have a strong incentive to get to the patent office quickly with your patent application, you have in some ways an even stronger incentive to publish your innovation, your invention, as early as you can, because you do get some exceptions, as we've talked about, to your own publications, and yet your potential competitors or your opponents in seeking patents don't get such exceptions. So you get an advantage, in essence, from your own publications, which means you have a strong incentive to publish early and then follow up, obviously, with a patent application. And so for that reason, although it's often referred to as first to file, it's probably really a first to disclose system, since the incentives here are for the first person to disclose, usually is going to be the one, assuming that they follow up within the grace period, usually is going to be the one to get the patent. And again, just a flag at the end here, it is only a 1-year grace period, so although the incentives are very strong to disclose early, you need to make sure that you diligently file your patent application within that 1-year period.